Everyone needs an estate plan. But the question I get more often than any other is, do I need a will or a trust? Answer is, it depends entirely on what you want your family to go through when you're gone. My name is JP Rankin. I'm an estate planning attorney licensed in South Carolina, North Carolina, and California. I've helped hundreds of families create an estate plan, avoid probate, and create a legacy that they're proud of and they know will work when they need it to the most. I'll explain in this video exactly when a will works or when a trust is better, and why most families actually need both. Let's start with the will. A will is a set of instructions for the court. It tells the court who gets what and who's in charge of making that happen. But your family can't use the will until it's approved by the court. That process is called probate, and it's required for most estates in both North and South Carolina. In North Carolina, that person's called the executor. In South Carolina, they're called the personal representative. But regardless of what they're called, they have to file the will, get appointed, publish notice to creditors, and keep a public record of every asset distributed. This process takes anywhere from 6 to 18 months, and anyone can walk in and read the file. So while a will is essential, it's not private, and it's definitely not fast. Let's talk about living trusts. Living trust avoids all of that. Instead of waiting on court approval, your successor trustee takes over immediately. They can manage assets if you're alive, but incapacitated, and then they can distribute those assets quickly after you pass. The trust owns the assets, not you individually. So there's no probate because there's no estate to open. Anything that's in your name when you pass away is part of your estate. So you stay in control while you're alive. You're the grantor and the initial trustee and technically the beneficiary while you're alive. And when you pass, your successor trustee follows your private instructions, no court involved. For tax purposes, under the IRS Code 2038, the assets are still included in your estate, so you keep your step-up in basis under Section 1014. That means no capital gains tax is assessed when they sell the properties that just received that step-up in basis. So which one's right for you? Let's definitely simplify it. If you own property in multiple states, use a trust. If you have minor children, you still need a will to name those guardians. Now, if you want privacy, trust is for you. If you're on a tight budget, a will is better than nothing. If you worry about incapacity or dementia, trust planning is essential. Most families actually benefit from having both, a trust to manage assets privately and a will to name guardians and cover anything that didn't make it into the trust. That's called a pour-over will, not a last will and testament. But those two things work together. Now, let's touch on taxes and control. A revocable trust won't lower your estate tax exposure because you still control it. But you can add provisions to split the trust after death into a credit shelter trust or a disclaimer trust to preserve both spouses' estate tax exemptions under Section 2010 of the IRS Code. That can save a couple of $1 million in future taxes. Here's the bottom line. A will tells the court what you want. A trust lets your family do it without asking permission. If you want to learn exactly what type of trust fits your situation, click the link below. Schedule a free consultation to come see us. I hope you found this helpful, and we'll see you in the next video.